The Suitcase Murder Trial is our top story this morning. A Florida judge is going to call in the pro se defendant, Sarah Boone, to address motions that she filed asking for help with her case from standby counsel and asking for help funding her defense. So before we talk more about that, let's get you caught up on the background of the case. Here's Court TV lead anchor Vinnie Politan.
911, what is the location of the emergency?
It's Monday, February 24th. There's a crisis at the home of Sarah Boone, prompting her to call 911.
Is this a police or medical?
My boyfriend is dead.
Okay, send a line for the fire department. Do not hang up.
The fire department takes over the call, and for the next few minutes, officials are obtaining critical details about what happened.
Now, tell me exactly what happened there.
My boyfriend and I were playing last night, and I put him in a case and we were playing. And it's like kind of hide and seek kind of thing. So I fell asleep, and I woke up, and he was dead in the suitcase, so I don't know what happened.
Okay, is he hanging from somewhere or what, ma'am?
No, I pulled him out of the suitcase. I tried giving him CPR.
Fire and rescue instruct Boone on how to give chest compressions.
Just keep on pumping. That's all you need to do for me. Keep on pumping his chest for me. I don't need you to stop and talk or anything. I just want you to count out loud for me, okay?
31, 32. Please hurry.
Okay, man, they're getting there as fast as they can, okay?
He's stiff and he's purple.
EMS arrived within minutes and advised Boone that her boyfriend, Jorge Torres, had been down too long and there was nothing more they could do. Boone explained she and Torres were drinking the night before and thought it would be funny if he got inside of a suitcase for a game of hide and seek. The next day, deputies returned and arrested Boone and charged her with second-degree murder in Torres's death. Boone's story about a childhood game gone awry unraveled when investigators say they found video on her cell phone showing Boone taunting and laughing at Torres while he was struggling to get out of the suitcase.
I can't breathe, babe.
Oh. That's what I feel like when you drink on me.
Sarah, I
Go.
can't breathe, Sarah.
Yeah. You should probably shut the
When police questioned Boone the next morning, she seemed to have no memory of that happening.
I fell asleep, so I don't know if he suffocated or if I got an aneurysm or a heart attack or what.
Boone told investigators she only realized her boyfriend was still in the suitcase when she woke up. Still, investigators say her actions add up to murder. Sarah Boone has pleaded not guilty and maintains her innocence.
Such a bizarre case. Joining us now with more information on Sarah Boone's latest filings as a pro se defendant, Court TV legal correspondent Kelly Craft is with us here in studio. Kelly, what can you tell us about these latest motions from the woman who's representing herself?
Yeah, hey there, Julia. Good morning to you. Good morning, everyone. Just such a bizarre story, as you said. So Sarah Boone, she is no stranger to filing so many motions in her court case. This is ahead of her October trial, and the judges said this is going to go to trial in October no matter what. So Sarah Boone, as you just heard Vinnie talk about, she's the woman charged with second-degree murder in the 2020 death of her then-boyfriend, Jorge Torres. So these are the handwritten motions. They are long, as I mentioned, handwritten, and they talk about the fact that she needs standby counsel, for instance, because she's not a trained attorney. She doesn't really know anything about the law, and that she doesn't have access to the internet. She only can use a payphone for about 15 minutes a day for each call that she has to make. She has really no access to computers, printers, anything that a normal attorney would have. So she said she's really at a disadvantage here. So another motion is this motion for the reservation of costs to hire an investigator as well as an expert witness for her trial. And as I was mentioning, her boyfriend, Jorge Torres, he died after Boone told authorities that she locked him in this suitcase during an alleged game of drunken hide and seek. And she did tell deputies that she passed out and awoke to him being unresponsive. So she has gone through several court-appointed attorneys to date, and at least she did hire one private attorney, and most of these attorneys have asked to withdraw due to irreconcilable differences. One saying that Boone walked out on her twice after she spent nearly 20 hours with her. Boone has accused her prior attorneys of not working with her, not being available, lying to her, and not having evidence available. So, Julia, today in court, what we expect to see, well, one thing I do want to mention is this Justice Administrative Commission here in Florida. So they actually took a look at these motions that she filed, and they put out kind of a preliminary ruling saying that it looks like she shouldn't get access to counsel. But you can take a look and see what they have. They're saying that as for the appointment of standby counsel, the court entered an order on June 28, 2024, finding that the defendant waived her right to court-appointed counsel through her conduct in this matter. Thus, the court has already ruled on this issue of appointed counsel. So during this hearing today, Julia, we do expect to hear from the judge, hear what he has to say on this. But as the commission is saying here, she's been through so many counsels already, waiving her right, not being happy with attorneys, and now we're in a situation where judge is saying October, we want this case to go to trial, and she's going to have to figure it out. But it will be interesting to see what he says during these hearings today.
Oh, it will be. She almost seems delusional because she is not giving up on this request for counsel, but she's getting close to trial. That's what she needs to be focusing on. Let's get some perspective from our criminal defense attorney and law professor Don Milarczyk, who is joining us. Don, I want to get you to weigh in and see if it's possible that the judge could give her an ultimatum. Could the judge say, you can have one more attorney, but if you get rid of this attorney, then that's it, we're still going to trial? Do you think that's possible?
Julia, I do think it's possible. And what is important here is the word standby counsel, which is different than appointed counsel who's going to be doing the work, asking the questions, doing cross-examination, entering exhibits, making objections. Standby counsel is different. Standby counsel is really what it sounds like. You're literally there in the courtroom waiting for the defendant who's pro se to ask you some questions during a break or during in between cross-examination. The defendant may have some questions. They have a right to consult with counsel, but that attorney is literally just standing by. He or she is not asking questions. They don't have an active role in the trial. They're there to help advise a pro se defendant on legal issues that come up, obviously, every day during a trial. And I think she has that unfettered right to standby counsel, which is different than everybody that she's had so far who's tried to represent her, and that's obviously resulted in a disaster. She's not happy with any of those attorneys.
Oh yeah, disaster is the key word there. And I've seen that before, Don, where there's been a standby counsel, and actually at the certain point in the trial, the standby counsel became the attorney for a person who thought they wanted to be pro se. It was different than Sarah Boone's case because this person wanted to represent themselves, and we don't have that with Sarah Boone. Let's take a look at some of these motions that, Kelly, you've been drawing out, and we have a bit of one where she's talking about what she's requesting. She wants collaboration, correct understanding, and overall perspective about her extraordinary circumstances. That's why she says she needs counsel, and it says it's rendering her cognitive incapacities. She thinks that that's something that needs to be brought up before the court. Procedural inabilities and extremely limited capabilities altogether as fact. She's mentioning these cognitive deficiencies. Do you see a possibility that she will try to or needs to be reevaluated to see if she is even competent to stand trial on her own?
I don't see that happening. And a lot of the things that she's talking about when we take a look at these motions is just the fact that she's not a trained attorney. And so we see this a lot of times in cases. Defendants said that they want to appear pro se. And then what happens is they get into the court of law and then they don't understand the rules of evidence. And so some things can end up being admitted into a trial that normally, if you had a trained professional, somebody who went to law school, passed the bar, is able to talk about and understands the rule of evidence. And so she's really talking about not having that capacity to be able to do this, and having that standby counsel could help her, guide her. I just have a hard time seeing that the judge is, he may allow this, but he is not happy with Sarah Boone. He's made that very clear time and time again. She has been able to delay going to trial because of her various handwritten motions that, as you can see, are very, very long and detailed, citing a lot of things that necessarily don't need to be cited in these motions. But I don't think the judge is going to be very happy with her today.
Don, do you think she's getting help? What's typical in these situations when we have someone who's behind bars? As Kelly said, she doesn't have access to the internet, she claims, and has a difficulty with these legal issues, but she is writing some very lengthy and detailed handwritten motions.
She is. And, you know, there's a lot of jailhouse lawyers and there's a lot of motions that are floating around, and you can look online to try to find these. And I'm imagining that's what she's doing. It's the worst of all possible situation for someone accused of a serious crime, that they think that they can do this on their own by talking to jailhouse lawyers, by spending 15, 20 minutes, 30 minutes in the library every day, by copying, cutting, and pasting motions together. And although they might be lengthy and they might have cites to cases, as we've heard, there's a lot in there that's completely irrelevant and means absolutely nothing. This is a nightmare for the judge, for the prosecution, and ultimately for the jurors if she's going to continue to represent herself.
And we're going to hear from her today, or standing by for that hearing that's going to happen later this hour. Let's take a listen to Sarah Boone and how she comes across to this judge. This is from a prior pretrial hearing.
I am thoroughly confused. Was the notice ever put online for this or mailed to anyone? I don't even know why Mr. Lane is here. I don't know why I'm here.
Well, ma'am, you are now representing yourself, and previously you had requested to appear at every hearing that was held. As you are now representing yourself, the court cannot have any hearings regarding your case without you being here.
Kelly, there's a balance that the judge has to do because there's a constitutional right to counsel. And despite these problems that she's had, the 8 attorneys that she's had so far, this could be an issue on appeal. What do you think?
Possibly. I mean, you would take a look, when we take a look at the appeals, we take a look at the previous history, and there is no question here that the judge has given her so many opportunities to have a counsel that works with her properly, and so that's what the appellate justices would take a look at. This request, though, is different in regard to it being the standby, so I think the judge is really gonna put forth a really clean record as to, you know, things to back up what ultimately he decides in this case. Getting her standby counsel, I would assume that we're going to end up seeing the same result if he does appoint standby counsel, which is she's not going to agree with what her standby counsel is saying to her either.
Don, can you weigh in as well? And I want to narrow it to, could she plead something? Is there an option for her to plead insanity in this case? And if she doesn't have a lawyer, she wouldn't be able to perhaps make that determination or even to file the right things to see if that is an option to her. Again, I asked Kelly about being fit to stand trial, and some of these things that we're hearing from her and seeing, there's a possibility. It's been raised on analysis. What do you think about her being in the position of being pro se, but the potential for these other defenses being out there?
It's absolutely a nightmare, and she may have those valid defenses. You know, there were some attorneys who early on said that perhaps this is a case that involves a defense of battered woman's syndrome, and that seems like honestly her best argument and her best defense, but that's a very nuanced claim, a subdivision really of self-defense that requires expert witnesses. It requires testing. It requires reports. There are deadlines when you have to get those reports in. It requires the expert to review all of the evidence, and all of that is difficult, if not impossible, when she's representing herself. So she's just making it incredibly difficult to effectively represent herself and advocate for herself on these various claims that she might have, including insanity, perhaps.
All right, Don Malarczyk, thank you so much for that analysis. Kelly Craft as well for bringing us the very latest.